public interest law is a fascinating sector of the nonprofit economy. These nonprofit law firms focus less on making money, and because that's not their job, they're nonprofits after all. Their job is to establish precedent, to create legal precedent that expands freedom, protects our constitutional rights. That is the currency of the realm in the nonprofit public litigation world. And a lot of these institutions, your Pacific Legal Foundations, Institute for Justice, some of the state based or regional ones like Mountain States Legal Foundation or Southeastern Legal Foundation, a lot of these came around in the 1970s. But over the past decade or so, there has been a resurgence of some new organizations that have popped up on the scene. And one of the ones that has flexed its muscle more than most is the Liberty Justice Center, based up in Chicago, but working around the country and really made its name several years ago with the Janus case. And we're going to get into that here in a little bit. But more recently, it has been making news for pushing back on the tariffs that this administration has been promoting. I am so pleased to have Sara Albrecht joining us. She is the chairman of the Liberty Justice Center, who has been a terrific voice for the growing organization. And this organization has really done some remarkable things, has made some noise, maybe made some enemies along the way, but also, most importantly, really established some important precedents. Sara, so good to see you.
Thank you, Peter.
So, as I said at the top, like there are a lot of public interest law firms out there. And to a certain extent, we need them because there's a lot of also really bad actors out there trying
A
to
lot of
undermine
work
our
that needs to be
constitutional
done.
rights. But how did Liberty Justice Center pop up in the first place? I mean, with so many other organizations, how did you find a lane that was worthy of saying we need a new group?
We were founded in 2011. So this year we're starting the first of our 2-year, 15-year anniversary celebration because we didn't get our paperwork tax ID number until 2012. So I always love a good chance to extend a celebration. We were based in Chicago at the time, and so we were working only in Illinois. And as you know, Illinois has more than its fair share of problems. And that's where we originated the Janus case. Mark Janus lives in Springfield, or he lived in Springfield at the time. And we signed him on as a client in 2015. We ended up at the Supreme Court in 2018. And then in 2019, we filed our first case outside of Illinois. And now we are in 36 states and Puerto Rico. We are based in 8 states with our attorneys. We're now kind of a virtual office. We recently changed our incorporation to Texas because one of our donors said, we're not giving money to organizations based in Illinois. So Texas it is. But I'm still in Illinois. This is my home. And there is a lot of work that needs to be done here.
So the launch then, was it just opportunistic because you had this case and you said we need a organization around it, or
We
was there a
launched
particular piece that
before
you
the
didn't think was being addressed?
We were kind of started as part of the legal arm of Illinois Policy Institute, and they were needing some legal advice. So they hired one attorney and an intern. That intern is still with us as the director of our staff attorneys. And so they were just doing kind of, there's a bad law that gets passed and we need to stop it. One of our early cases was we fought for a food truck that couldn't get licensed in Evanston. It's called Beaver's Donuts. And the city was making them go through, a lot of, startup issues, licensing issues that they shouldn't have to do. So we fought for their rights to operate and run their business as they see fit. The city started to implement a plan to tax Netflix. And this was very early on. And so we challenged that. And certainly there was a number of union things that came up. And our governor that was elected around 2015, Bruce Rauner, was very intent on kind of breaking the power of the unions. And so we had this idea that, okay, let's find a plaintiff. We literally were cold calling people who had voted for Republicans and who were, we thought, probably employed by a school system. And that's how we found Mark and 2 other plaintiffs in that case.
All right, so let's talk about the Janus case because this really puts you on the map,
Yes.
quite literally. Big deal case, and launched 1,000 ships. Lots of people took credit for it, but it was Liberty Justice Center's case, and it
Yes,
was
it
really
was.
important. So, talk to us about this Janus decision, uh, what it was, and I'm sure we've talked about it on the show before. I think people have some understanding of it, but more importantly, what did that victory do for Liberty Justice Center?
Yeah. So prior to Janus, you were kind of forced to join a union if you were a public sector employee. Post Janus, you are not compelled to join a union as a condition of employment as a public sector employee. So you can opt out of the union, not pay your $1,000 to $1,500 dues every year, put that money back in your pocket, still be represented by the union, still have all the benefits of the union, but you get to keep more money and you're not forced. It was really a free speech case because we argue that it was compelled speech joining a union that had very vocal, and as we know, even since 2018, they've become more political and more vocal. And if you don't agree with that, you shouldn't have to pay to fund that speech. So that was also kind of the accidental case. So at the time, I don't know if you recall, we were not going to be in front of the Supreme Court. There was another case called Friedrichs, and that was a case out in California that was heard at the Supreme Court. Then, tragically, Justice Scalia died suddenly. And so that case ended up in a 4-4 tie. And then we got kind of bumped up, and they're like, okay, well, this is the same issue. This is, a case that needs to be decided, and they brought Janus up. And so that's one of the reasons why groups like ours file multiple cases in multiple circuits, because you never know uh, when a situation like that happens, and then you need another case to be able to kind of step in and continue the argument forward. Um, so that's kind of the origin of Janus. And now the work that so many other amazing organizations do is helping these employees get out of the union. You would think that winning a case like that, and they said you don't have to join, you would have mass exodus from the unions. What we found is unions lie, public sector unions lie. I mean, there is a big difference between private and public, and they narrowly give parameters that you can exit. 4 days in August, if it's a full moon and your name starts with A, you can leave the union. I mean, I'm exaggerating a little bit, but they make it very difficult. So that's why so many groups are out there doing Janus work, kind of post Janus work, to get people out of the unions and to let them know their rights.
Yeah, and to me, I mean, that's the public interest law firms do so much heavy lifting to get to a point, and then it does open the door for all these other organizations to step in and do what they're good at, right? And it's a multi-step process. But going sticking with Janice for a second, I mean, so many people see the final result. They say, "Oh wow, you went to the Supreme Court. You are suddenly at the Supreme Court," as the overnight success type of thing that
Mhm.
takes years to build. Help our listeners understand what does it really take to get a Janus type case from idea to Supreme Court, both in time and in sweat equity and in financial resources.
Right. So I have kind of like two extremes because we can like switch to tariffs in a second. Um, it really just takes an idea and a team dedicated to that idea. I think one of the things groups like ours struggle with are we have these ideas. It's hard to find plaintiffs and citizens or businesses to step forward and serve as the voice or the face of an issue like this. And certainly in Mark Janus's case, he was he turned out to be he's still on staff at LJC. He's our senior fellow. He goes around the country speaking about unions. He's working on a book right now. Um, but you need someone who's committed because it's not easy. He would have unions follow him around the state, putting that inflatable rat up wherever he was speaking.
I've seen the rat.
Um, I think they had like an intern that just carried the rat from speaking engagement to speaking engagement. He had death threats. He had kind of a crazy person show up at his house one day. We had to get him security for a while. Um, And certainly we also experienced that as the attorneys and the organization on the case. So it takes a lot. In that case, we partnered with National Right to Work, and they were amazing partners. And Bill Messinger argued it at the Supreme Court with us. And so the resources, it took a lot, but it didn't take the amount of resources that the tariff case took because I hired high powered outside counsel to really help shape that argument because it was a little, um, there were too many moving parts to it. Um, so that's kind of, all the cases we take, we like to have a path to the Supreme Court because we're not just out there providing pro bono legal services. We're trying to set precedent and make change and set good precedent and move and advance the constitutional rights for everybody and kind of help solidify those rights along the way.
Much because the left does this too. They've got their own public interest law firms, I would imagine. How does the approach on the left differ from kind of what Liberty Justice Center, Institute for Justice, Civic Legal, all of the ones on the more libertarian conservative right do, other than just the outcomes that we want? Maybe it's just the outcomes. I'm just curious about that.
I think maybe it's just the outcomes. I think like we try and message our cases and our work founded in and based on the Constitution, not policy, preferences or political preferences. It doesn't matter who's in office. If they're breaking the law and violating people's rights, we're going to sue them. So I think maybe that's probably the biggest difference is they're a little more, they use the media in more extreme ways than we do.
Well, your answer tees us up nicely to talking about the tariffs case because you're right. It doesn't matter who's in office, conservative, liberal, Republican, Democrat. The Constitution is the Constitution, and that's what you're out to protect, and the rules of the road for America. So you took on the president, Donald Trump, and his tariff thing. Why? Why'd you
Well,
launch into that?
yeah, that's a question I ask myself every morning. Um, yeah, I mean, I think I've been very public about. I voted for the president 3 times. This had nothing to do with the president. Nobody at Liberty Justice Center suffers from Trump derangement syndrome. It wasn't about that. It was about the Constitution and the separation of powers. And we saw this statute, this IEPA statute that he used to levy these tariffs, being used in a way that it was not intended for, in our opinion. Well, clearly our opinion was right. Um, and, you know, also would open up a door for unbounded power to do similar things, with the next executive, whether it's a Democrat or a Republican. And you could really see a pathway where this could be abused and you could just not stop it. So if we didn't stop it now, like it's really hard to put the genie back in the bottle. And there's a reason they have that saying because it is really hard to once you have, oh, well, he used it for this. So why can't we use it for, you know, these 3 other things that are even worse? So it was a constitutional issue. We didn't, I don't think we grasped the enormity of the uh, underlying issue, the case, the effects on the world at the time, because the tariffs at that point were all new. We didn't know what was going to happen. We didn't know if it was just a negotiating thing, like maybe in a month he'd pull them off. Um, so anything could have happened. So we had this idea. We're like, okay, this is wrong. It is a kind of a beautiful chance to have a separation of powers argument that's so kind of clean and that we can present. It's like a once in a lifetime opportunity. So we basically had the briefs written, and then the guys said, "Oh, we need plaintiffs." So then you have to find people to say, "Oh, sure, I don't mind suing Donald Trump because how bad could that be?"
And how
Well,
do you? I mean, you don't put an ad in the paper, like
no. So it was funny. We were in strategic planning process. And so Jeff, our lead attorney, our director of litigation, and I were carpooling out to the strategic planning location. And on the way, I would just start dialing businesses that either were donors or that I knew or that I knew somebody else knew, and just talking to them about, hey, we have this idea. We're thinking about filing this case. What, you know, talk to me about how you're seeing this issue, how you would view being a plaintiff in this case. What are things we need to concern ourselves with from your side of the equation? Um, and that really helped kind of inform who we were going to need to look for as we were doing that exercise. It helped with like, how are we going to message this in the media? We've got all these weird things going on, tariffs that people think that foreign countries are paying, which is not true at all. We've got a court that we're filing in that nobody has ever heard of. And then we've got the leader of the free world who is going to be really mad when we file this case. So, and the time frame, just to give you a sense of how quickly, I know a lot of people thought this took a long time, but in legal world, this was lightning speed, how we got from April 14th, 2025 to a decision at the Supreme Court, February 20th, 2026. So we were having these conversations April 1st. Tariffs started April 2nd. We filed on April 14th. We had our court date on May 13th. I mean, it just was a very quick progression. So we didn't put an ad in. We had posted some things on social media. There was another constitutional law professor, Ilya Soman at George Mason, who was talking about the same things. And um, unbeknownst to us, he put a blog post out that said, "Hey, Liberty Justice Center wants to file this case if you're a business,"
So
which is
they kind
something
of put out an ad for you.
pretty much. And all of a sudden, like, my phone's blowing up. We're in the strategic planning meeting. Jeff's phone is blowing up. We're like, what is going on? All of a sudden, we're getting these businesses emailing saying, hey, we'd love to help. I'm like, wow, this is easier than we thought. And then we realized that this Twitter post was out there. So we took a list and then we kind of split it up between our team members. And then it's, interviewing, because you also need someone who's going to be able to speak to the media, who's going to stick with the case through the long haul. Even though it was only a year, they have to these are small business owners. It's hard enough to run your business in the best of times, let alone being a lead plaintiff in a case that the entire world is looking at. And the most powerful person in the world is your enemy at this point. So we looked for people that were going to stick it out. We needed stories that were easy to tell. We wanted a diverse group of countries that they imported from versus, just China, because China isn't necessarily the most sympathetic of countries to import from. Also, people that hadn't been on social media with aggressive comments against the administration, things like that. So we probably talked to a couple hundred people and
Wow.
had detailed notes. And then we all met and we kind of pitched, who we think would be the best people and why. We settled on this group of 5 plaintiffs. Clearly, I think everybody on the call probably is familiar with our lead plaintiff, Victor Schwartz, who runs VOS Selections. And he turned out to be better than anybody could have ever hoped for in a plaintiff. And I couldn't be happier with that choice. We have these 5 groups, 5 businesses. Straight out of the gate, 2 of the businesses said, no, we don't want any media. This has become all of a sudden way too much for our businesses, and we're getting a lot of blowback. So we're going to stick with the case, but we just don't want to be the public face of it. That's fine. We had 3 other people that could cover that. That's one of the reasons you see, multiple plaintiffs in a case.
Oh, it's interesting. Yeah, and I guess a cynic could say, well, you're just shopping for your perfect plaintiff. But what I'm hearing you say is you want plaintiffs
Yeah,
that
I am shopping for
are
my
are
perfect
almost
plaintiff.
aren't too perfect, but you need them to be representative of what the case really is, right? If you just had somebody who was importing from Vietnam, all of a sudden the case is about imports from Vietnam. It can distract from the real issue at hand, I'd imagine.
Yeah, and, like, kind of the underlying I think the final like, what made Victor so good is, I always use this example, like, I could explain it to my mother in 30 seconds. Like, she's a Republican also, so she was very, conflicted with what was going on. I'm like, "Look, he's talking about, he being the president, bringing manufacturing back to the United States. And so these tariffs are, in theory, supposed to do that. Well, Victor Schwartz imports wine from other countries. How do you manufacture Spanish wine in the United States? You can't. Why is that American business, third generation of a family business, being penalized? It's like, oh, I never thought about it like that.
That the messaging component of this, and this is not just a liberty justice issue. I mean, I talk to a lot of the think tanks. I have a lot of friends running think tanks. Some of them in Republican states where you would think that they would always be on the right side of the governor, but they're not. I mean, sometimes you got to push back on your friends. How how did you, as a team, kind of mentally prepare for that?
Um, I don't know if we did. Honestly, it was all happening so quickly. I guess I thought we were just it was so obvious to us that this was the right argument and we were on the right side of the law here that I just assumed everybody would see that and everybody would agree and there'd be no blowback. I did not anticipate the blowback from friends, like friends in the network, friends in the movement, donors. I lost a significant amount of donors over this that probably will never come back. I do the same thing all over again. Like, we made a good decision. I think one of the comments I heard, which was very fair and I hadn't thought of, I was talking to a foundation that has funded us in the past. I'm like, hey, would you be interested in this? And they said, why would we put right of center money towards this issue, challenging a, Republican president? I said, well, because I feel like we can message it differently than if the left had taken this up. If back to your comments about the left of center groups, um, they would have had a whole different messaging. It would have been all about the president. We never made it about the president. Um, we made it about the executive. We made it about uh, the office, not the man in the office. And I think we did a really good job of that, and we stayed on message, and we stayed on message. Our plaintiffs stayed on message. There weren't any kind of rants out there on social media. I think our attorneys that we brought in down the road in the case for the appellate level, they clearly had different political views than some of us. They all stayed on message. This was not about President Trump. When he engaged with us, we didn't engage back because we're never going to win that battle. So just being very disciplined. And the thing that was probably the hardest was when our case got consolidated with the 12 states, we were actually in active litigation against three of those states. So I had the AGs saying, well, we want to be in the press conference after the hearing with you guys. And I'm like, and there was their press people. I'm like, I really don't think that's a good idea. Like, oh no, it'll be fine. I'm like, no, and so I shared some of our social media posts with them. They're like, "Oh, yeah. How about you guys go first and we'll go after you separately?"
As you said earlier, I mean, to the end that this is about setting precedent, the real enemy, the acute enemy is the issue that's on the table, but the precedent in that you're trying to set means that this doesn't become an issue later. Because you're right, the next administration could have brought this up, two later. I mean, there's a lot of short term thinking if people are solely in the political world. That's why I like being in the nonprofit world, right? In this philanthropic space, because we get to think a little
Mhm.
bit more long term. So, take us behind the curtain a little bit for just a minute. Just you're preparing to go into the Supreme Court. Those chambers, very august.
Okay, I'm getting chills just as you're saying it, Peter, because it was so amazing. Anyway, go on. What
It's
was
a
your
cool
question?
thing, and I've been in there not during litigation, like not just an empty courtroom, and it's still a great room to be in. but the pressure is on. I mean, you've got what is it? You basically have 30 minutes and you might say 6 words. Your attorney may say 6, 7 words, and all of a sudden the judges are just throwing questions at you, right? How do you even prepare mentally, on paper for that? Is it different than just going to, the normal circuit court?
Well, yeah, it's incredibly different. I think I'm going to take you back a step because the government appealed after we won in a unanimous decision, appealed to the Court of Appeals for the Federal Circuit. And there we were heard in front of what they call an en banc panel, which means, on the bench, so all the justices,
All of
all the
them, yeah.
judges that are at the Federal Circuit sat
Because
to listen.
normally it would just be 3 of them. Is that right?
Yeah. And so the courts, normally you would have to ask for this. So normal process, you're heard in front of a 3-judge panel. You lose or win, the other side appeals, and then you could say, I want to be heard en banc. And sometimes that's en banc just reviews the brief. Sometimes you actually have another hearing. Well, in this case, the Federal Circuit said, okay, we know you're going to the Supreme Court. We're going to kind of skip that interim level and go straight to en banc. So there, we had 11 judges that we had to argue in front of. And these judges they hear trade cases all the time. So it was very technical. You are absolutely right. We got 3 words out and then it was, firing right and left. And, our attorney had all their names written down in front of them and in front of him so he could, make sure. They also like to be addressed by their name. So it's like, yes, Judge Moore, Judge Clark, Judge Toronto. Um, so that was good practice. And then getting ready for the Supreme Court, we also didn't have a lot of time. So we had to get our briefs done. We had to kind of corral all our amicus support. And then we just did really intensive moot courts. So bringing in other attorneys, other constitutional scholars, and just practiced. And they fired questions. And it wasn't like easy questions. You're there to kind of be mean as a judge, like be the worst judge, but the best judge. So you're kind
I
of
mean, it's
ready
the
for
final
anything.
exam. It's the doctoral dissertation. I mean,
Yeah. I
it's
mean,
the ball
it's
game.
everything. And what was really kind of fun is Georgetown has this moot court, it's set up to look like a mini Supreme Court, even down to the carpeting. And so we sat in there. We had all these law students that were there. It was probably 4 hours of grilling. Um, and it was just amazing. So we did 5 of those.
Okay, so you win
Win.
finally. There's finally a victory. Now you, being a glutton for punishment, seem to be continuing on the tariff pursuit of, okay, we have won. The legal precedent has been established, but now there's this refund question. Now, if it was wrong, therefore there is some recourse required of people. You all are taking that mantle up too. Is that right?
Yeah, and this goes back to the same thing I was saying in Janus. It's one thing to win, but then the second part and the hardest part and the part that a lot of people forget about or don't follow through with is making sure that that opinion, ruling, decision gets executed. So in our case, the Supreme Court didn't address refunds because we didn't ask them to, because if they declare it unconstitutional, then those tariffs should not have been paid and should be paid back. So we had a permanent injunction sitting at the Court of International Trade. So that had been set aside. And so we just had to kind of get the case back down to the Court of International Trade. So filed a motion to go back to the Federal Circuit, and the Federal Circuit had to kind of pass it back to the Court of International Trade. And there we sit. And so in the meantime, all these other corporations, small businesses have been filing these cases to get refunds. So those cases are stacking up at the Court of International Trade. By the time we got back there, uh, like 1,500 cases had been filed. All of those cases were set aside because they needed to decide on the refunds and it was going to apply to everybody. So they kind of came up with a plan. There's one judge in charge of all of the cases, working with CBP, Customs and Border Protection. coming up with this 45-day plan that is supposed to start April 20th. In theory, the refund should be automatic. You just have to do very simple paperwork. You should not have to file another lawsuit to get that money back. It will be paid back with interest because interest is statutory. Because there's always refunds in tariff cases. So what happens is, and if this is too much in the weeds, you can let me know. You pay your tariff up front. So you have something coming to the port, you pay your tariff, then 314 days later, you go through a process called liquidation. And that means you have to make sure that you paid the right tariff. CBP has to make sure you paid the right tariff. Sometimes it's too much, sometimes it's too little. And so you liquidate the claim and you kind of true up what it is. Do I owe you money? Do you owe me money? And so in the case of the IEPA tariffs, they are going to liquidate those claims as if IEPA never existed. So kind of remove that. So when you go to liquidate, it's like, oh, you paid all these 99 tariffs. That's the code for IEPA. That's gone. So we just owe you money. And that flows back to the importer of record, not consumers, not citizens who maybe had price increases, but only the importer who actually paid the tariffs at origination.
Is this something that will go back to the Supreme Court, or in theory, because you've kind of put the legal wheels in motion, it should, in theory, be on autopilot?
It should be on autopilot.
You're almost in watchdog mode.
I am in definite watchdog mode. So when we were first heard back at CIT, this judge, Judge Eaton, who is amazing, um, he was listening to CBP and the government, and then attorneys for another case that he'd used as like a representative of the classes of cases. And he was kind of making some rulings and making some suggestions. And the government said, oh, but we haven't had a chance to submit our briefs on the merits. And the judge said, merits? There are no merits. You lost at the Supreme Court. You have to pay this back. And then the government attorney, I felt kind of bad for her. Then she started like scrambling to file motions to kind of, slow the process down. And he was like, denied, denied, denied. So he knows the enormity. I mean, it's $166 billion. And just to remind everybody, that money goes back to American businesses that employ American people, that buy American machinery. A lot of, these decisions had to be put on hold. Like, we can't buy this machine because we spent all the money on tariffs. Hopefully now they can. They can hire that person. They can pay bonuses that they weren't able to pay last Christmas. So maybe I'm naive, but I think these are going to be paid. I think 80% of them will be in the pockets by the end of the year. It shouldn't have to go back to the Supreme Court. The government can probably make it difficult, but I think they've got some other things they need to worry about right now.
So what is next for Liberty Justice Center? What's the next big case you're taking on, or is it, not to diminish some of the smaller cases that maybe you win at lower
They're all
courts,
big
but
cases.
they're all big cases. They all set precedent.
Yeah. Well, we have this other case. So after we won the tariff case, 5 hours later, he instituted the new round of tariffs using Section 122. So we filed a case against that. We felt like we needed to kind of finish what we started. So we were just heard at the Court of International Trade on April 10th. Expect that to go to the federal circuit and maybe the Supreme Court, or maybe the government will just give up. Again, probably not going to happen. So after that, we're done with tariffs. We're not a trade law firm. We're still a constitutional law firm. But if you're going to pull out these statutes, these dormant statutes, like rummage around your kitchen drawer and find an old statute that you've never used and like, oh, we can now use this for tariffs, we're going to tell you you can't do that. Next big cases. So we are still working on public sector unions. We've got an interesting project we're working with Philip Howard on. Basically, bottom line, at the end of the project, perfect world, public sector unions are unconstitutional. Period. Hard stop. probably not going to happen, but I think we can make some interesting precedent and progress towards taking some more power away from the public sector unions. I think Janus, some of the estimates say we've taken $1 billion out of public sector unions' pockets since the decision in 2018, and that's an annual number. So if we could, chip away at some of that power, that would be great. And then certainly there's free speech issues that come up all the time. There's different types of government overreach. And then we also work in educational freedom. So right now we've got a case in Vermont. They have a the oldest school choice program in the country. They're trying to chip away at that and kind of eliminate that. We're trying to expand it. So we're filing we have one case filed against a law that was trying to restrict town tuitioning. And then the follow-on case is then to expand it so more people are eligible for that tuitioning program. So,
That's great. Well,
just little things like that.
and unfortunately, there's no shortage of things to go after. Governments, how many state, local, municipal, and federal governments are there that branches of the federal government, different administrations. I mean, there's a lot of people doing not great things, and we're glad to know that Liberty Justice Center, as well as this broader panoply of public sector or public interest law firms that I know you also work with and get along with, uh, are out there because we need them.
Yeah, we're not competing. We're all working together because I would love us to not have any work and to be able to go out of business. That means the world is an amazing place to live in. Unfortunately, I don't see that happening.
Not yet, but
Not yet.
you keep you keep chipping away. Sarah Albrecht, thank you so much.
Thank you, Peter.
Well, I am not a lawyer. Probably made that pretty evident in the conversation there, but I am really glad there are smart legal minds who are getting up every day and working to advance pro freedom issues. Liberty Justice Center is a welcome addition to the pantheon of good public interest law firms that are working to serve the Constitution, protect the Constitution, along with some other newer groups such as New Civil Liberties Alliance, America First Legal, and Fairness Center. As we heard, these cases can take years to work their way from idea to Supreme Court. A lot of them never even make it to the Supreme Court. Those are the big sexy ones that we often hear about, but a lot of really important things are happening at lower appellate level, circuit level courts, state Supreme Courts, and those matter too. And these same groups, the old guard, the newer ones, are all taking up these issues every day to preserve our liberties. Well, if you would like to learn more about the Liberty Justice Center, you can find out more about them, get links to their website in the show notes of this podcast, and I hope you will. And if you are looking for a partner to be more smart and strategic, effective, and principled in your philanthropic giving, that is what we do at Donors Trust, and we would love to be helpful to you in those efforts. Go to donorstrust.org. You can take a peek at our new look website. But the promise of the work we do is unchanged. We are still helping conservative and libertarian donors to simplify, protect, and grow their charitable giving. That is what we do. Nothing's changing there. We are built to preserve donor intent and help this movement grow. Well, thank you for tuning in. Thank you for being part of this conversation, and look forward to having you join us for the next one. Until then, thank you for being a giver. Talk more soon.